Gosh, I have been involved with DPI probably since the very beginning. I was working with Nandan on the sides on Aadhaar and around the right to privacy type of issues, worked a lot around the privacy principles that have to be built into an identity system. And then most recently I got involved in DEPA, the Data Empowerment and Protection Architecture, and that's a very privacy preserving type of architecture, but it is a very different type of architecture. And to explain that in the context of data protection laws, as well as to explain to all the people who are building it how to embed privacy data protection principles into the design of the infrastructure, was where I was involved. Over the years, in all the various DPIs, all these various issues that keep coming up around open markets, competition, open source software, then of course a lot of the contractual design and all of those sorts of things. So yeah, off and on, maybe 15 years, I've been hovering on the outskirts of the DPI ecosystem, but very much working on the role of law and governance with DPI. The most important thing to understand when you're looking at governance for digital public infrastructure is that you have the traditional frameworks, and the traditional frameworks are the waterfall, as I see it, is statutes and then contracts. And statutes are broken up into constitutional provisions, then actual laws, delegated legislation, which is regulations. And then once you've got all of that, because governance is described by these things, and this is all well before we get to contracts. And then once you've sorted out the governance frameworks in this the set of statutes and the set of documents, you then move to inter-party governance, which is between the participants of the DPI ecosystem. That's covered in contracts. But when you're thinking about DPI, you have an additional way to look at this, and that is that it is possible for you to build these legal principles directly into the code of the infrastructure. And so really that's where I started from. I was like, look, we've got the laws, we've got the regulations, we've got the contracts, but we can also actually embed these principles directly into the infrastructure. And once you have that, then I think it takes two levels of skill. One is to understand what the technology can do, what it is doing, and then to understand how legal principles can actually be incorporated into the code and the design of the way the infrastructure is built. So I think that is where I started. But as you get more and more into that, you realize that, look, you can embed design legal principles into the design of DPI, but you have to have some kind of contractual framework, and then we rethought the way the contractual framework would be designed. See, these are all massive multi-party systems, and so if you do traditional bipartite contracts, you will struggle. And so we had to come up with this ecosystem participation terms concept, where you've got this central pillar around which people sort of agree to participate based on their role. So it's a role-based participation on a standard agreement. Depending on what role you have, your obligations are inherited from the way in which that central pillar is designed. But even that is not enough. You need to have then actual institutional governance frameworks. So you need to have an institutional framework for who's going to decide what the protocols are going to be, who's going to decide what version 2 of the ecosystem participation terms are going to be. And for that you need to have technical standards organizations which will determine what the protocols would be, what the next level of protocols would be. And you need to have self-regulatory organizations which will, within the sectoral ecosystem, decide the actual way in which participation will take place. In many of these sectors, you require certification, and you require constant audits, and you require various new features and new products that come out into the ecosystem. How do we ensure that they align with the legal principles? So that's the institutional governance design. So if I was just to sum up, we've got the traditional provisions, which is laws, regulations, contracts. you've got the ability to embed legal principles from laws, regulation, and contracts directly into the code. And then you've got governance of institutions that are required to maintain the code, that are required to evolve the code, and also just maintain the ecosystem. And this is the full range of legal instruments that you have when you're working in this space. The point is that you're looking to build for the ecosystem. You're not building for an individual or for an individual entity. When you're building for an individual entity, you will put in belts and braces. That's what we call it in legal terms. You'll put in a clause and then you'll put another clause. Even though that first clause dealt with everything, you're like, look, I don't know, maybe there's a need to put another clause in. And that's sort of the approach. Now, when you're building for the ecosystem, you're actually putting yourself in the shoes of all the participants of the ecosystem, and you're trying to figure out, what is in the interests of all these people. Now, when you're thinking ecosystem, you'll realize that the belts and braces you would put in for just the one entity is actually coming in the way of the benefits to the other entity, or the way in which the other entity will function. And when you realize that, you start to strip down what your ask is, because every ask that you put in is something that you're detracting from someone else in the ecosystem in terms of what they can do, or the mitigations they get, etc. And therefore, the only way to build ecosystem contracts where you're not the top, the head honcho of the ecosystem, and everyone else is going to do what you say. You are literally negotiating this for the weakest chain in the link as well. In that type of environment, you will find that you will actually build out the most minimal contract. But I think it's one step further. I think when you build an end-to-end digital ecosystem, a lot of what lawyers would traditionally put into a contract can actually be delivered through code. What do I mean by this? When we are engaging with each other as human beings, as persons, I can't control how you perform. I can only impose an obligation on you under a contract. But if you're functioning in a digital ecosystem, the way the code operates is almost as good as a law. In which case, I don't have to tell you to do A, B, C, or I don't have to say that if I do A, you will do B. Because the code is designed such that when it receives input A, it will deliver output B. And I don't really now need to make this part of the contract, because it will happen. So the next level of minimization that we took is we went through the workflows, the digital workflows, and we eliminated from contractual obligations all those workflows that typically we would put into a contract, but which are now being performed in code. And so the net result of these two actions was that we got a very minimal kind of a contract. Of course, negotiating this is a challenge, because the other side is so used to seeing the clauses in the contract that we had to tell them, okay, look, you want the obligation, we will give you the obligation, but we're actually giving the obligation in code. So you should not be negotiating liability. You should be testing whether the code actually performs as we promise it would perform. So it's a slight shift in the way in which the lawyers and the business people think. In other circumstances, the business people are telling the lawyers, have you protected my downside? Now we're forcing the business people to tell the software developers, does the code perform as it is advertised? Because if it does, then I don't have to insist that the lawyers put this in, because it will perform as it is. So this is another shift in thinking that is only possible in these kinds of digital public infrastructure, because it is at a sector-wide level. Every entity in the sector that is performing this particular service is performing it on this digital infrastructure. And so we can make sure that the digital infrastructure itself is actually operating almost like a contract, and ensuring that all the parties perform their contracts. And I'll take it one step further, because obviously if the digital infrastructure fails, then some obligation will not be performed. If there's an outage and a server doesn't work, and you've got a 9-layer set of events, at the 7th layer the server is not working, and therefore the transaction isn't complete. What we said was we will put in place dashboards we will put in place red and green lights to say that if we started the transaction, if all the lights are green, that means the transaction is true. If the light is red, we will see how many of the 7 lights were green before it turned to red. And if the 5th light is red, then we know that at that 5th transaction it failed. And so we've also got a very powerful dispute resolution mechanism to say that, look, it's your fault that the transaction didn't go through because your server failed or because something happened at that place. And rather than put the blame on, I don't know who, we'll say, look, 7 people are supposed to do things, we didn't know who did it, we now have to go to court and decide. We don't have to do any of that because the evidence is clear in the dashboard. So these are the features that you will get when you're trying to build governance mechanisms directly into code. The idea is, and in the governance and the legal frameworks for DPI, we borrowed heavily from the actual principles of DPI. Unbundling as an example. This minimization is essentially stripping out the things which are not important. That's a very DPI principle. We unbundle the DPI to its atomic element, and then we put it together. We did the same thing with the contract. We stripped it down to its core elements, and then we put it together. Modularity. We designed the legal framework such that there is an identity governance framework, and that identity governance framework can be strapped on to a commerce framework such that you have an end-to-end solution for, G2P payments, where the identity piece and all the privacy protections around the identity piece is in that identity element. But that forms part of the entire G2P solution because the identity piece, the legal and the governance pieces around that is dealt with already in the system, and we don't have to rewrite that again. So that whole reuse, modularity, all of those things are built in. And then, federated data, also keeping a lot of these systems federated such that we don't concentrate data into a single place. That's very much a data security obligation under various legal frameworks, and that's how we implement that. So you're right. I think there are many borrowings that we have done from the way in which DPI as a technology has been built and the way in which the governance of DPI has been conceived of in this framework. I think we need to recognize that many things keep changing. None of these systems that we build are static and should not be static. I think a lot of the design of DPI is such that it can evolve. Evolvability is a core element of digital public infrastructure. And evolvability, therefore, has to also be a core element of the governance of digital public infrastructure. So I'd mentioned 2 institutions for governance, TSOs and SROs. TSOs are technical standards organizations. So to answer your question about new technologies, AI, but it could even be new products. We come into this, into a financial services industry thinking that we want to give loans to people, but actually we realize that we want to do wealth management for them. And so we need new products that are coming out. And the protocols that we've written may be protocols for loans, but we actually need protocols for wealth management. All of that will be dealt with by the Technical Standards Organization, which will say that, look, now AI has come in and we need to make this available in multiple languages. And rather than insist that it be translated in multiple languages, let's just make an API to plug a Bhashani type language in or some language translation in such that whichever country we are in the world, we can translate it to whichever language is relevant. That would be done by the Technical Standards Organization because it may require a modification of the existing protocol to incorporate a new standard, a new technical standard. And then you've got the contracts, the legal frameworks, you've got certification and audit, various of these sorts of things that in a particular sector will be surfaced by a self-regulating organization. So an SRO or a self-regulating organization in a given sector is an entity or an institution that understands that space very well. So let's say in the financial services sector, you'll have an SRO in the financial services sector to say, look, when we're talking about data sharing or data exchange in the financial services sector, these are the problems that are coming up. People are saying that I need this additional new product or what you've built me works really well for loans, but it's not working so well for wealth management. There are these additional features that I need. And then we will say that, okay, now in order to put these additional features, we need some regulations or we need some additional certification. And then the SRO will come up and say, okay, we need these amendments to be done from the legal side, the contractual side, the regulatory side, and perhaps even the statutory side. And obviously, the SRO can't amend the laws, that has to be done by Parliament, but the SRO can certainly say that on the ground, we're finding these problems with the way the law works, and so can we recommend this change? So these are the two ways in which I think is the most practical way in which you evolve. I think if you wait for legislators to make the change, they will only make the change once there's enough complaints in the system that this is not working. That's probably too late. Having SROs on the ground and TSOs on the ground are people who are actually implementing these DPIs, and they are finding that there are some actual problems on the ground as we're implementing it, and they can surface it up much faster. So this would be a way to actually evolve the legal frameworks at the same pace as DPI will evolve the technical frameworks. Extremely challenging. As you're saying, lawyers are only used to dealing with contracts, and to convince them that this would perform in code was extremely challenging. Now, of course, I had an ally in the fact that the first person I had to convince was Pramod. Pramod Rao was at that point in time the general counsel of ICICI Bank, and I spent a lot of time, having this conversation with him. I wouldn't say a lot of time, compared to the total amount of time we spent trying to put this ecosystem together. It was actually quite easy to speak with Pramod and get him to understand. But once I could get him to understand, in a sense, he was my ally, and he would, having understood the power and the potential of this, and in his own ecosystem realized that actually this will work. It was then much easier because we've got a general counsel of a big bank, well respected in the banking sector, who could then go and in their own language convince other general counsels of other banks to say, look, this is how we think it will work. This, we're comfortable with this. I think you can also get comfortable. And then, of course, there's a bit of a momentum with this. Once 3-4 banks say yes, it's okay, and it's also when the transactions are working and you're finding that we really don't need these clauses, the code is performing as advertised, it becomes easier. So, my experience with this is you have to put in a lot of effort to try and change the path the first time. And with some time, and as long as the system is effective. See, the moment the system doesn't work, then of course everything comes crashing down. The pendulum is swinging in the completely opposite direction. But so long as the system works as advertised, and as more and more people are comfortable and convinced of it, then it works. When a country is looking to build a legal framework for governance, I think the instinctive response for any government is to try and see if I can build it into a law or a regulation or something like that. My only advice to them is that you have another tool, and that is to actually embed these legal principles directly into the infrastructure. You have the power to do it because you are the one who is signing off on the protocols that are being performed. And you can insist that the protocols have certain legal functions. Now, the power of this is that as much as you think your laws are powerful, your laws have to be enforced. And as much as you've written it in the statute book, people can violate it until they get caught. The advantage of writing it into code is you cannot violate it at all, because the code only performs in a binary way, either yes or no. And that is the power of, instead of trying to put it into law that 100 people will violate, or maybe 100,000 people will violate before you actually get it to the court to adjudicate on. You can put it into the infrastructure so that no one can violate. Now, that is the power of understanding this approach. And so I strongly urge countries that are looking to do this to actually first articulate what it is, what are the legal principles that they want to enshrine into their digital public infrastructure. It could be a combination of, I want to have free markets. I want to ensure no monopolies can take place. I want to ensure that everyone has autonomy. I want to ensure that no data is taken without consent. Or it could be any slight subset of this. It could be, in certain circumstances, I want data to be sent because this is for the good of the country. Whatever it is, you have to decide upfront, these are the principles that I want to govern this particular sector. Some of those principles you have to enshrine into law. And I think almost all the principles have to derive its sustenance from the Constitution or some overarching legal framework that the country is bound by. But a lot of them, instead of putting it into delegated legislation, can actually be put into the code and the design of the infrastructure. And if you can do that, you will get everyone participating on the infrastructure, both the private sector parties, the government entities, everyone participating in that infrastructure will, just by the act of participating in that infrastructure, comply with the legal principles and the laws and the frameworks. And that's an extremely powerful thing for a country to have.